Every time you buy groceries, pay a mechanic, or download a piece of software, you enter into a legally binding agreement. For most of us, these daily transactions are almost invisible. But scale that up. When a transaction involves moving thousands of tons of steel and electronics across international waters, the stakes change. A business purchasing goods overseas rarely owns the vessels, the cranes, or the trucks required to transport them. They have to rely on a complex chain of independent carriers, insurers, and logistics providers. If any single entity in that chain fails to execute their specific role, the entire operation stalls. Millions of dollars of cargo sit idle. To prevent systemic failure, there has to be a mechanism to legally mandate performance or recover the resulting financial losses. This is the exact function of contract law. It is the structural foundation upon which all other commercial statutes, like carriage law, insurance law, and the sale of goods, are built. It takes a casual business understanding and converts it into a legally binding obligation with severe financial consequences for failure. Knowing exactly what specific statutory conditions must be met to lock two parties into this framework is a fundamental prerequisite for operating in commercial shipping. Every commercial transaction starts at the exact same baseline, an agreement. The basic legal formula is simple. One party makes a proposal, and the other accepts it, creating an agreement. But not every agreement qualifies as a contract. Secondary criteria must be met before it becomes legally binding. Under Section 10, an agreement graduates to a contract only if enforceable by law. It must clear 5 hurdles: competent parties, free consent, legal consideration, lawful object, and it cannot be expressly declared void. If an agreement fails even one of these tests, it collapses. For shipping executives, the 2 criteria that trigger the most frequent legal failures are capacity and free consent. This list details the statutory requirements for capacity to contract under Section 11. The law proactively assumes certain parties cannot protect their own commercial interests. The most rigid application of this rule applies to minors. Anyone under the age of majority is entirely barred from making a binding agreement. Any contract attempted by a minor is void ab initio. This legal term means the agreement is treated as non-existent from the very beginning. This standard was permanently cemented in 1903 by the Privy Council in the landmark case of Moharib Bibi versus Darmodas Ghose. In this case, Darmodas, a minor, mortgaged his property to secure a loan. Crucially, the moneylender advanced the funds despite knowing perfectly well that the borrower was underage. When the dispute reached the court, the Privy Council ruled that the mortgage was entirely void. The moneylender lost the ability to recover any of the advanced funds. The rationale was absolute. If the court ordered the minor to repay the loan, they would be using the power of the state to enforce an agreement that never existed. Section 12 applies a similar binary to mental capacity. A party must have a sound mind, defined as the cognitive ability to form a rational judgment about their interests. In the Indar Singh case, a property worth 25,000 rupees was agreed to be sold for just 7,000. Seeing this extreme undervaluation, the court found the seller lacked mental capacity and declared the sale void. Capacity acts as an absolute legal binary. If you transact with a party who fails this test, the legal system treats the transaction as if it never occurred, offering zero protection to the other side. Beyond capacity, the parties must achieve free consent. Both parties must agree upon the exact same thing in the exact same sense. If their minds are directed toward different things, the alignment fails, and a true legal agreement does not form. The law identifies 5 hazards that shatter this alignment: coercion, undue influence, fraud, misrepresentation, and mistake. But when consent is compromised by these factors, the resulting agreements do not all fail in the exact same way. If an agreement is based on a mutual mistake, it is classified strictly as void under Section 2G of the Contract Act. It is legally dead, completely unenforceable by anyone. However, if consent is extracted through coercion, fraud, undue influence, or misrepresentation, the contract becomes voidable under Section 2I. It remains legally valid, but only at the option of the wronged party. They hold exclusive power to cancel the agreement entirely or enforce it. In a multi-million-dollar shipping dispute, knowing whether a defective contract is totally void or merely voidable dictates your entire strategy. It is the difference between a deal that is dead on arrival and a strategic liability you can leverage to recover your cargo. We can now see the complete legal architecture: capacity, free consent, consideration, lawful object, and validity. When these 5 pillars are secured, an agreement solidifies into a commercial contract. These abstract rules dictate the physical movement of global trade. The steel hulls crossing oceans operate under parameters defined by historical case law. Everyday operational documents like bills of lading, charters, and contracts of guarantee lock into this exact framework. They draw their enforcing power directly from this foundation. A mutual proposal and acceptance will create the agreement, but only capacity, free consent, and a lawful object grant the power of enforcement. For maritime professionals, Section 10 functions as the primary risk management tool required to successfully navigate international trade.